You're a few months out from your wedding, and your company just granted you another block of RSUs on top of the 200,000 shares already vesting over the next 4 years, worth roughly $4 million on paper.
Your fiancé's attorney raised the idea of a prenup. Yours hasn't addressed what happens to unvested stock if the marriage doesn't work out, and in DC, a portion of that grant can already count as marital property before a single share vests.
This video covers what a DC prenuptial agreement can and cannot protect when equity compensation is part of the picture.
A frequent concern people bring to me is whether a prenup can actually protect stock that hasn't vested yet or perhaps hasn't even been granted yet. To start addressing these financial stakes, we really have to look at whether legal protections can even apply to future unearned assets.
The legal reality in Washington and D.C. is quite clear on this. D.C. Code Section 46-501 defines property in a premarital agreement to include present or future interests, whether they are vested or contingent. Because of this broad statutory language, unvested RSUs and unexercised stock options can absolutely be set as separate property before the wedding.
This leads us to a critical distinction. How does DC actually treat RSUs differently from stock options and deferred compensation? While the statutory law treats all of these as future interests, the tax mechanics for each specific instrument dictate exactly how they must be structured in your agreement.
Take incentive stock options, or ISOs, and non-qualified stock options, NSOs. They are taxed very differently, which fundamentally changes how each gets disclosed and drafted. ISOs, for instance, can trigger alternative minimum tax exposure at exercise. Meanwhile, NSOs are taxed as ordinary income at exercise, making them much more straightforward to value and assign within a prenup.
Keep in mind, your compensation probably isn't limited to just standard options or RSUs. High-earning professionals must also account for other deferred benefits, things like deferred cash, stock appreciation rights, and phantom equity. These complex assets silently accrue value during the marriage, and without explicit contractual terms defining their ownership, they become highly vulnerable during a separation.
Which brings us back to the default reality. If I get married without a prenup, what happens to my unvested RSUs and stock options in a DC divorce? Well, if you skip the agreement entirely and rely on DC's default equitable distribution rules, the courts will step in to divide anything earned while married.
Without a prenup, DC courts apply what's known as a coverture formula to RSUs and options that vest during the marriage. To calculate this, they divide the days of marriage that overlap the vesting period by the total vesting period. It's a strict mathematical approach used to determine exactly what fraction of your labor belongs to the marital estate.
So consider the impact on a standard 4-year grant that started 2 years before the wedding. Applying that coverture formula, that single grant comes out roughly half marital property and half separate property.
If you want to see the exact coverture math worked out with real numbers, the full breakdown is linked in the first comment below.
Now, writing the rules down is really only half the process. Enforcing them requires absolute financial transparency at the time of signing. So, what do you actually have to disclose about your equity for a prenup to hold up in DC Superior Court?
The standard is set by DC Code Section 46-506, which requires full financial disclosure of all equity holdings before signing. The logic here is straightforward. You cannot legally waive a right to an asset if you aren't given a fair and reasonable opportunity to understand its true value.
The consequences for hiding the ball are severe. Simply put, incomplete disclosure voids the agreement. If a spouse can show they were not given fair and reasonable disclosure, a DC court can void the specific equity clause, or they can strike down the entire prenuptial agreement entirely. Assuming your disclosure is thorough, we face another major question regarding timelines. Does a prenup only cover the equity you hold today, or future grants and promotions too? This question leads directly to the most critical oversight family law attorneys see during asset division.
A prenup that lists only today's stock grants leaves every single future grant unprotected. That includes things like annual refresh grants, performance bonuses, and entirely new employer awards you haven't even anticipated yet.
Leaving that gap is the single most expensive drafting mistake in equity-heavy DC prenups. Protecting only what is currently on your cap table ignores the reality of how modern executive compensation structures evolve over the course of a career.
But what if the wedding day's already passed? People often ask, I'm already married without a prenup, is there still a way to protect future equity?
For professionals who are already married but anticipating massive future equity compensation, the legal window actually has not closed.
While you cannot retroactively protect shares that have already vested as marital property, D.C. law allows you to secure future grants through a postnuptial agreement. A postnuptial agreement is a contract signed during marriage, offering prospective protection for future assets, and it uses the exact same statutory framework as a prenuptial agreement.
A DC prenup only protects the equity it names, today's grants, future grants, and how each instrument gets valued, so a generic template leaves gaps for anyone with meaningful stock compensation.
The full article breaks down the 3 ways D.C. courts split unvested shares at divorce and what complete disclosure actually requires, and it's linked in the first comment below.
Subscribe for DC family law guidance like this without searching for it every time.
Take a hard look at your evolving compensation package and consider carefully, is your current financial trajectory fully protected before you say I do?